Welcome to Seeking Disability, the show that helps you in seeking disability. I'm Tom Duncan of Duncan Disability Law.
And I'm Dana Duncan.
So, where we left off last time in discussing the sequential process, and we would encourage people to go back and listen to episode 2 before listening to this one, because a lot more will make sense. But a question we often get is, do I need an attorney or a representative? And while we kind of commented there on it at the end, especially for the step 5 of the sequential process, what are some other ways in which we would encourage people to either consult an attorney or a representative, and why you may or may not need one?
People ask me all the time if they need a lawyer to go through the disability process. I'm sure I've mentioned this before, but no, you don't need one. You also don't need a surgeon to take out your appendix or a dentist to do your root canal. I just don't think any of the three of those you should do alone.
There are a lot of different nuances and little parts to understanding not only Social Security law, but how it's often applied by the administration. And unless you're kind of trained in this area, you don't always know what is going to befall you. Sometimes you could be at the mercy of Social Security themselves, which judge you get on a particular day. And if you're trying to do it on your own, you're not going to be able to fight through a lot of the little barriers that Social Security puts up to try and get in your way.
Fortunately, about 85% of all the workers in the Social Security Administration are conscientious, good people who are trying to help. Unfortunately, there's about 15 to 20% who think they're playing gotcha. So even though while you're filling out papers in the initial process, you may think you're answering the question the way they want it or how you should answer it, how you phrase it makes all the difference in the world. And sometimes something that you think is so meaningless or innocuous, that doesn't have any meaning at all, can be what your whole case rests on. That's why if you want to have a representative, you almost want to get it from the very start, because in my office, it's always a strong recommendation to do so early so that we can control what is being sent to Social Security, so that we present your case in the best light possible. That does not mean we're presenting it falsely. No, it means we're just helping you to better express your thoughts and your conditions so that people understand it and you don't hurt your own case.
Now, let me take you through at least a few of the different stages here. If you're about to start an initial application, seek an attorney. If you've just been denied your initial application, seek an attorney. If you are planning on appealing that initial application denial, seek an attorney. Basically, at any stage, you can consult an attorney. I mean, I'm being a little bit facetious here by going through each and every individual stage here, but at any point in the process, you should probably consult an attorney if you have not already. The one clarification that I will make is, once you get to a certain point, you've been through your hearing, you've appealed to the Appeals Council, which is an administrative body out in Virginia that reviews all of the hearing decisions for the entire country. If after that point you've been denied, then you absolutely 100% need an attorney to look over stuff. You can file on your own in federal court, but good luck getting a federal judge to agree with you who doesn't necessarily understand the very small differences in the law.
Let me give you an example of something that people don't understand how different it is when you have the knowledge necessary to represent people. For example, Social Security sends you a form and it basically asks you how you spend your day. And they'll say things like, "Do you do your dishes?" And people will go, "Yes, I do my dishes." That in and of itself can hurt you, because what you should be doing is going, "Yes, I do my dishes, except that I have to sit on a stool to do my dishes because I can't stand at the sink to do them. Bending over that little bit bothers me. And in fact, I can do my dishes no more than a few at a time for 10 or 15 minutes, and then I have to go lay down because my back is hurting so bad." The difference is yes, I do my dishes versus the explanation necessary to explain all you have to do in order to do that very basic daily activity.
Certainly, even something as small as I leave the house to go grocery shopping can be held against you if you're not presenting it in the right way.
And what ends up happening is you find out, well, yeah, I do shop, but I haven't been shopping without my husband for 5 years because I can't be there alone. Or the number of times I've been at the store and I go at 9:30 at night because there's nobody in the store. And then too many people come in and I end up leaving and just walking away with my grocery cart still full and going out to the car because I'm having a panic attack. Those are the things that you really need to be putting down.
Here's a fun little nuance that's come up on a couple of occasions recently for me. I had somebody who said that they were attending all of their doctor's appointments, except all of their doctor's appointments were telehealth. Now, the difference in the nuance between I'm going to my appointments, meaning you get up, you prepare yourself, you get dressed, you shower, you clean yourself, you leave the house, you drive somewhere, and you're in public, versus I sit potentially in my pajamas and have an appointment over my computer is vast. The way in which the small, slight differences in wording, and that's frankly what most of law is just trying to get the right words on the page and present the right words in front of the right person at the right time.
Yes. Another area that lawyers or representatives can help is every administrative law judge has different views on things. And if you know your representative or your representative knows the judge well enough as to how he or she thinks, you can present your case differently. One of the rules in my office is you always tell me who the judge is in your case if you're asking me a question about something, because how you present it makes a difference. And some judges don't like it if you have a history of alcohol and drug abuse. If that's the case, you better have your client well prepared. For example, if they're sober and they're in AA, they better be prepared to talk about what's happening with their AA program, how far they are along, what's their sobriety date, how many chips they've earned, because that will convince a judge that you're maintaining your sobriety.
So obviously there are a lot of nuances and pitfalls and different things that a lawyer can help you through during this process. And obviously, while we're biased, we do think it is very important that you consult an attorney and or representative. Okay, so you've decided that you're going to consult an attorney or representative. I know what the next big question you're going to ask is going to be. How much does it cost? Well, Dad, what do you say?
Well, it's simple. You don't pay anything up front. You only pay a representative if you win your benefits. You don't have to worry about coming up with money. We understand you're not working, so it's taken care of that way. And we get paid. Yes, we will. When we lose a case, we lose the time we spent on it, but that's our job. And we know that we were going to do this and we work hard for our clients and try to make sure we win. And so that's what ultimately happens. It's 25% of your back pay. The back pay is calculated from the date you're found disabled until the award or the decision's issued. It does not take into account the fact, we don't get paid like other lawyers. Like if you know anything about personal injury or car accidents, that type of thing, they get future wages. We don't. We only get based on that past amount. And it's regulated by Social Security. So it's not like we can just take money. Social Security and the administration and the administrative law judges have the authority to approve our fees. And not just the authority, the responsibility to approve fees. So it's protected.
Maybe to explain that just slightly further. Let's say, for example, that you're alleging that your disability started on January 1st of 2024 and you were found disabled on January 1st of 2025. So you would have exactly 12 months worth of potential disability that you should have been receiving payments for that you didn't get. That's your back pay. Now, there's some additional calculations and nuances having to do with that, but let's just assume for the sake of round numbers here that you were meant to be receiving up to $1,000 a month for 12 months. That's $12,000. Out of that, a representative can collect up to 25%. So that's going to be $3,000. But that's not money that is coming directly out of your pocket. It's not upfront. That's if you were awarded benefits. And so that's the great benefit to you in applying for disability. You can consult an attorney without having to pay them in advance for their services. Of course, there's a lot more information to share, but that's a good place to stop for this episode. If you have more questions about disability, you can visit our website, duncandisability.com, or call 1-888-458-2406 to talk to the Duncan Disability staff. Thank you for listening. We'll see you next time. Seeking Disability is a production of Ronnie Duncan Studios. This show is written by Dana and Thomas Duncan. It is mixed, edited, and recorded by Thomas Duncan. Our music is thanks to Purple Planet Music. Our technical provider is Riverside FM, and our distributor is Captivate FM.